Fantastic. And we're live. That's great. So thank you very much for attending today. It's awesome to see so many faces. And one particular face there that I've not seen in an awful long time. And we'll catch up with him at some point in the future, but lovely to see you, Mike. Thank you very much for joining the session today, another session hosted by the Chamber on HR and employment law today. And I'd first and foremost like to thank Nikki, Becky and Claire for giving up their time today to walk us through what has been a particularly challenging world, especially in the last year, especially with regards to employment law. I'm sure you guys haven't had a single moment of silence with regards to changes and updates and various other things. So with that, we're going to have sort of a Q&A session today. So I'm going to walk through some questions at the same time as well. It would be fantastic for people to put their questions in the chat. We'll get round to those as we go. There's quite a few topics that the team would like to cover today, just purely and simply because there's so many very different things going on, from holidays, sickness and pay inquiries, refusal to work, self-isolation. There's been changes, hasn't there, recently with regards to inbound people into the UK. So there's all sorts of things to cover and discuss. With that though, if you could possibly share your contact details in the chat, that'd be fantastic as well. So if anybody wants to reach out to anyone else afterwards, they can do so. And yeah, I guess let's get started. Nikki, I know that we've discussed this many times this year, but there's so many things changed in terms of people having to work from home. When you think about, most organizations, their kind of holiday year is, 1st of April to the 31st of March. What happens in a world where employees have got tons of holiday left, right, as a result of working from home? They've not been able to take it. What can they do in those scenarios?
Okay, well that's quite a common question that we're getting asked at the moment, is the holiday situation and what do we do? Because as you say, our employees have either cancelled any holidays that they'd requested and we perhaps allowed them to be cancelling them, or perhaps people just don't want to be taking them, and businesses haven't, in my experience, necessarily, it's not been at the forefront of their mind to be talking to employees about taking holiday over the last 12 months. So it is something that is very prevalent at the moment. It's something that I'm getting asked lots of questions about, and in fact I have throughout the last 9-10 months now. There is no straightforward answer to this. In terms of holiday, it does also depend on where we are sitting at that moment in time. So are we talking about whether we're in lockdown, or are we talking about employees that are on furlough, or are we talking about employees that are still working in the workplace? Are we talking about employees that haven't been able to take any holiday, the NHS, for example, because they've been working flat out? So there's lots of different situations and circumstances. So my advice would always be case sensitive, but sort of as a general broad brush, if you like, if we take an example of lockdown, so we're currently in lockdown again at the moment. I think this is our 3rd lockdown. I'm starting to lose count, to be honest with you, but anyway. I am getting questions as well, can I ask my employees, because as you rightly say, a lot of holiday years are April until the end of March. The other favourite seems to be January until the end of December. So if somebody is, if we're in lockdown and you want to be requiring employees to be taking holiday, there's a number of considerations which we have to think about. The starting point really is, what is the purpose of holiday? I think a lot of us tend to forget what actually is the purpose of holiday. And obviously under regulations, purpose of holiday is to allow an employee to rest and relax. Rest, relax, recuperate, enjoy themselves, that sort of thing. Now, depending what stage that we're at, whether you're in tier 1, 2, 3, 4 or lockdown, then I think there's an argument as to what the restrictions are that are imposed on the employee, and therefore whether they can actually relax and enjoy a period of holiday. So it's arguable that, let's use the example of lockdown, so it's arguable that if you are in a period of lockdown whereby no shops are open, I'm not quite sure whether this seems to be the case this time round, but anyway, no shops are open, no pubs are open, you can't be going anywhere, you can't be going on holiday, and that's not the be all and end all, in my view, the flying abroad part. But actually, if you can't go anywhere and you're confined to your house, then arguably by requiring an employee to be taking holiday, is that actually in accordance with the working time regulations? Is that employee actually able to be relaxing, recuperating, unwinding and enjoying themselves? Arguably, no, they can't. But then there is another argument back that actually, okay, although that you can't perhaps leave the house, although you obviously can to do periods of exercise, but actually you're not required to log on to the system if you're a home worker because you're on holiday, or if you can't work from home and you need to go into the workplace if you're a key worker, then actually you're not being required to be travelling to attend the workplace. So there is actually an argument that you could be taking holiday because you can still relax and unwind and enjoy yourself, albeit in a slightly different way, I suppose, than what you might have done, say, 2 years ago. Now, this is an untested a piece of law at the moment. This hasn't been tested. This needs to really at some point, and I think it probably will at some point, go through the courts for a judge to make the decision as to whether or not you can actually require someone to be taking holiday during lockdown and furlough and all the rest of it. But I think it depends on the individual situation, and I do think there are arguments for and against, depending which way you'd like to be arguing it. Again, it's different. What if somebody is on furlough? Can you require them to be taking holiday? Well, again, that's another arguable point, isn't it? I think, again, very similar to the first example of lockdown, it depends on the restrictions that are imposed. I think if you are able to be going out and doing things, then I think there is an argument that you can require an employee to be taking holiday. And I don't think that would breach the working time regulations. But as I say, it's an uncharted argument at the moment. So there are arguments either way. What I will also just say one final point, so my clients have forgotten this, is that if you do require an employee to be taking holiday, they are, of course, to be paid 100% pay. So if they are on furlough, then you, of course, do need to top it up to the 100% pay.
That's a great point. And yeah, I mean, there's a lot of complications just in that requirement. I think as well, you know, when I think of employment evolved, there was always the scenario where at the end of my holiday year, if I had some holiday entitlement left, you know, I could carry over a few days, but that was typically at the discretion of the business. Becky, just a question regarding this. I mean, you know, if you have a use it or lose it policy within the organization and your approach to holiday, but your staff haven't been able to take it as a result of furlough or just being too busy, let's keep that into some kind of context. You know, is there a way that they're entitled to carry this forwards? Is it, you know?
Yeah, well, yes, for some, not for others. So under the working time regulations, you've got two different requirements. You've got 4 weeks, which was the original amount. That has to, under normal circumstances, be taken within the holiday year, unless you're off sick or maternity, it's due to sickness or maternity. There was then an additional 1.6 weeks that was brought in, and that could always be carried over for up to a year at the employer's, at the agreement between the employee and the employer. If you happen to offer holiday over and above those 5.6 weeks, that's contractual holiday. You can do what you like with that. You can agree that with your staff, what they do with that. Back in March last year, in recognition of the situation, the government made some emergency changes to the working time regulations to say that 4 weeks that you ordinarily used to have to take within that calendar year for health and safety reasons, essentially, you could carry it over for up to 2 holiday years, and that's the employer's holiday year, so the end of the holiday year over, if you had been prevented from taking it due to reasons connected with COVID. Now that can be interpreted quite widely. The ACAS, so what it actually says is, as a result of the effects of the coronavirus, including on the worker, the employer, the wider economy or society, so really quite wide there. But ACAS has suggested it might include if people are self-isolating, if they're too sick to be able to work, if they've been laid off, but predominantly I think if they're required to work. So if you're looking at, you know, health sector and people like that who've been basically working really hard, or where you've had to furlough some of your employees, so your other staff are off. So these people have really been prevented from being able to take their holidays due to COVID. It is up to the employer to be able to roll over some of that holiday, some of that 4 weeks for into subsequent years, so the next 2 years, to prevent them taking it. So the idea is it's flexibility between the employer and the employee. There's no right to employers to specifically insist that that happens. And what I would recommend from a health and safety point of view is, as much as possible, you put the facilities in place for your employees to be able to take their holiday in the holiday year. But if they have been prevented from doing that because of reasons connected with COVID, then it is up to the employer. Won't be in breach of the working time regulations by rolling that over. Just touching on what Nikki said, you can insist that your staff take notice, take holiday or don't take holiday at a particular time, as long as you give the required notice. What I would say is that holidays are a health and safety matter. Ensure your staff take their holiday and holiday if they can. And if they really can't, then roll it, due to COVID, roll it over if you can, but manage that, because what you don't want is a massive backlog of it, and you don't want exhausted staff. It just, final point, goes without saying that you still can't pay in lieu of holiday. It is still illegal to pay in lieu of holiday, statutory holiday, that's that 5.6 weeks. But contractual holiday you probably could pay in lieu of if you wanted to do that.
And I assume at that point you could potentially give your employees the choice of, the contractual holiday, in that, would you like to be paid it? Would you like to carry that over? You can have that conversation around it.
Contractual is up to what you do with it. The statutory holiday, the 4 weeks can now be carried over, which could never be carried, can now be carried over for 2 holiday years. The 1.6 weeks could always, subject to agreement, be carried over for an additional year. So, but I think it's in everybody's interest that staff are taking regular holidays where they can, and for employers as well.
I think it's worth sorry, Ollie. I think it's also worth perhaps saying, because I did come across, I bet Claire and Becky, you do as well. A lot of my clients clients often wait until the end of the year and then saying, oh, there's all of this holiday to be taken, which in normal years, if you like, can we say that anymore? I don't know. But it used to be that you get towards the end of the holiday year and there would still be some holiday left, but largely most holiday would have been taken. So the odd day here and there wouldn't cause any problems. Now I'm finding that clients are getting to the end of the year and actually the vast majority of holiday is untaken. It has always been good practice for a business to review the holiday that staff have taken at various points throughout the year. Now there's no set time, but I'd maybe say when you get to 6 months, review, oh, hang on, people haven't really taken holiday, and just remind staff you have this holiday to be taking, and then maybe sort of another 3 months later, remind staff. And then if you've ever got any problems or any kickback from employees alleging that you haven't allowed them to be taking holiday, then you can evidence by way of a paper trail that you have been actually reminding staff nicely that there is this holiday to be taken. If you don't take it, then you're going to, ordinarily as it used to be, certainly, if you don't take it, then you're going to be losing it. So that's always been good practice, to just keep a note of, how much holiday people have taken and how much is outstanding.
That's a great point. And I think a lot of businesses fell foul of that towards the end of last year. I know that from talking to many colleagues, where they had a lot of employees that hadn't taken sufficient holiday through the year because everybody was in head down and trying to get done. But also from the employee perspective, it was like, well, I can't go anywhere, so I'm not going to take holiday. So you had, two different forces working there. As a business, I know that we offered pay in lieu for any holiday that wasn't on statutory, and over and above that, we've allowed staff to carry holiday as well. So again, just as a balance. So that leads on. I mean, when you start, we'll loop back to the holiday bit towards the end, because there's another, other challenges around holiday, which we'll come on to, and the government's just recently announced as well. But with regards to, sickness and pay, I mean, I know there's a lot of queries out there, and there's a lot of changes out there at the moment with regards to that. So, Claire, for instance, if you've got employees that are on furlough at the moment right now, and they become sick and are told to self-isolate, what are the requirements? What do we need to take into consideration as employers at that point in time? Do we still need to pay them? How does that work?
Thanks, Ollie. So there are 2 options available if somebody is currently on furlough but unwell or told to self-isolate. So it's up to the employer to decide whether to keep them on furlough and pay them furlough pay, or whether to move them across to statutory sick pay. If the employee remains on furlough pay, then the government will continue to pay. However, if they move to statutory sick pay, then it is for the employer to pay, and they can no longer continue to claim through the furlough scheme during that period of time. The difference in pay between the furlough scheme and statutory sick pay often creates a risk that the furloughed employees might not actually tell their employer that they are sick on the basis that furlough pay is greater than statutory sick pay. So it is important to encourage employees to have a good reporting culture so that they are clear on what the policy is and that they have to communicate, even if they're on furlough, if they are unwell. This is particularly important from a wellbeing point of view, and also because you need to support your employees, especially if they have contracted COVID. Mm-hmm. So in terms of the procedure, it has slightly changed during the pandemic because obviously GP appointments aren't so readily available. So after the first 7 days, normally an employee has to provide a fit note. Due to there being less appointments available, the NHS now has an online system where it does provide fit notes, especially in relation to if you're being told to self-isolate. So you can send them to your employer instead. And you need to just look at adapting your procedure in relation to sickness absence in that respect, because they won't necessarily get the documents when they need or would normally get them. So there may be a slight delay in the current circumstances.
Okay, I mean that's a really sensitive area, right, from the employee's perspective, but also the employer as being able to be open and honest about these things, because you know the opportunity to end up infecting others and also not being clear as to what the guidance is can lead to an awful lot of problems. Nikki, just out of interest, if you've got an employee who is not furloughed but having to self-isolate, and this really, you know, this applies to many different things at the moment, not just if I contract COVID today, but then think about what happens if I return from a foreign country with COVID, and we'll talk about that in a bit more detail a little bit later. But in that scenario, I'm not on furlough, I'm self-isolating at home. Do I, as an employer, have to pay my staff during self-isolation?
So again, from a self-isolation point of view, again, all of these answers, and I hate saying this because this is such a lawyery answer, but it's always dependent on the individual case. It always is. But again, as a general brush, you know, is this person able to work from home, or is this somebody that should, you know, that needs to be in the workplace to be working? Technically, if somebody's self-isolating, and this is actually something that I was reading about a little while ago, or a week or so ago, is, and I'm going off piste a wee bit, I will come back onto subject matter, but actually for those that are home working, ordinarily when you would have had to go into the office, if you were ill, then you may have not gone into work because you were ill, you know, sickness or whatever. Whereas actually now, people that are home working are more, I think the concern is that they're more inclined to continue working even if they're not very well, because actually who's really going to know about it, and all you're doing is popping into your lounge or spare room or whatever to be working. It's not quite the same as having to get on, you know, public transport or get in your car and go into the workplace. But anyway, so that may be something that becomes an issue that we need to be looking at and just being aware of going forward, whether staff are actually telling us whether they are ill or whether they are actually fit to be working. But going back to Ollie's question, so yeah, so if you've got somebody who is not furloughed, they are working for you, but they're isolated, they need to self-isolate and they can't and perhaps shouldn't be working because they are self-isolating, then what are they entitled to be paid? Well, under the statutory sick pay regulations, they've been amended, as Becky referred to, some emergency legislation that was brought in last year. And one of the very many amendments was in respect of the statutory sick pay regulations. What the government did is they extended the definition, trying to keep it as simplistic as possible and as unboring as possible. They extended the definition of what deemed incapacity includes, and it expressly includes self-isolation. Now, the guidance goes a little bit further also to be talking about what self-isolation is. I'm not going to pull out, there's about 7 bullet points or so, but in essence, it's talking about those people that are experiencing symptoms. It's talking about those people that are living with somebody who's self-isolating. And it's also talking about people that have been advised by the track and trace system. I don't know whether I dare talk about that too much, but anyway, and it advises somebody that they've been in contact through that mechanism with an infected person. So if an employee is self-isolating, then they would be entitled to SSP, because they would fall within the definition of deemed incapacity under the regulations. Now, there's another issue there, though, isn't there? What if somebody is entitled to an enhanced sickness pay? So a lot of contracts tend to provide for statutory sick pay if an employee is ill, but there are still contracts, obviously, that provide for contractual sick pay. So usually something over and above SSP. Now, isn't as always the case, it's not quite as simple, my answer there, I'm afraid. So if somebody is self-isolating and they've got a contractual right to a contractual sick pay, they may or may not be entitled to that contractual sick pay, because it will depend on what their contract says. So if the contract refers to the employee being entitled to the contractual sick pay based on the same eligibility as for SSP, then it's likely that they would be entitled to the contractual sick pay. If, however, the definition of sickness within that policy doesn't directly link with the eligibility for statutory sick pay, then they may not be. So in essence, you would need to be looking at what your contract says to be able to decide whether they should be entitled to contractual sick pay or not.
Okay, and on that basis, just really quick before we jump to a question that's in the chat, but you touch on a number of points there. From my perspective, you know, sickness to me has meant basically the loss of my able bodily functions, not a cold or a flu. And when I say that, you know, working in a lot of organizations, you know, people didn't take time off unless they were really sick, right? You can take the definition of sick as to whatever that is. If you're in a scenario where you're having to self-isolate because you're COVID positive, but you're asymptomatic because you're not expressing any symptoms or anything else, you're still able to function and do your job effectively, but from home, at that point in time, are you forced onto sick pay, or do you have the opportunity to continue working?
Okay, so again, it depends, doesn't it? It depends, yeah. So it depends on what your job is. So if you're required to work in the workplace, if you have to be, let's say, on a factory line, that job can't be done from home. So in that case, if you're self-isolating, obviously you can't be doing the job, and therefore you would be paid SSP or perhaps contractual sick pay, depending. If you can work from home, or indeed you have been working from home, then absolutely you can, if the employee is in agreement as well, then yes, they can continue home working and therefore be paid their normal rate of pay.
Awesome. So that's really a conversation for the employee to have with the employer around, you know, what the options are at that point. And I guess in those scenarios when the employee is able to work from home, for them to judge best as to what, you know, what they want to do in that situation, in agreement with the company, right? Yeah, there's a fantastic question from, I'm not going to even try and get your name right. I'm sorry. If I, is it Sivket? Is that correct? Sorry. The question is do we have any workers' competence or performance criteria in the UK? And how's that changed as a result of COVID? Have we seen changes to workers' performance?
Shall I start on that one? So I think you're talking about so we're talking about performance, aren't we? Again, that's depends on the individual business, doesn't it? So if I think about my clients, actually a lot of my clients have seen improved performance, improved outputs on their KPIs. Actually, some of my clients' businesses are doing fantastically well, which is brilliant. Yes, there are some people that are underperforming, if that's what the question is. And yeah, it's a difficult one, isn't it? Performance managing people remotely. I do recall many years ago, we, the HR sector through the Cambridgeshire Chamber, we were talking, weren't we, Becky, Claire and Ollie? We were talking about more agile working. We were talking about businesses allowing employees to be grown-ups, if you like, where possible, allowing people to homework. And a lot of questions that I always got pushed back on was, well, how do I know that person's working? How do I manage them? And now fast forward a few years, and here we are. I'm not getting that many questions, actually, I've got to be honest, from my clients. I've had a few, but I've not had that many from them saying that they think that somebody isn't pulling their weight. And I think, to be honest with you, there's a whole load of factors now. We're in lockdown. So, you know, a lot of people are caring for their children whilst also trying to home work. That has to be a factor that an employer takes into account. You cannot expect the same output during the working day when somebody is looking after their child. Now, I'm not saying that you shouldn't be expecting there to be an output, but there has to be a degree of flexibility now. And a lot of a lot of people are working, different hours. They're working into the evening, or they're getting up and they're working earlier in the mornings. So I don't know if that answers your question. Is it Begat? I'm going to try and pronounce that. But that's just my experiences, but I don't know if that answers your question. I don't know what Claire or Becky think.
Yeah, I think that's great. We can loop back to it at the end and dive in a bit deeper. I think the only reason for that is the limited time that we've got, and I know there's a number of other things that we want to get through. Okay. Becky, real quick one. As an employee, if I refuse to travel into the office because, I'm fearful of COVID-19, I've heard all these bad things in the press about variant mutations. I've got a real anxiety issue. What's the responsibility of the employer at that point, and what should they be paying the employee?
Okay. The health and safety duty of an employer doesn't extend to the travel to work. That's outside of the employer's area of responsibility. However, an employee, if they are really fearful about a return to work and they don't believe it's safe, they can say they don't want to come to work for health and safety reasons, and that can extend to the travel to work. And if the employer dismisses the person as a result of that, then that could well be unfair. What I would say on a practical front, I think there will be quite a few cases where people have been dismissed in a COVID situation, and it's assessing whether or not that was unfair at the time. What I would say is consider, obviously, if the person can work from home, that's absolutely fine. If you can put them on furlough, again, that would be another option. If not, and the person has to actually be at work, then consider additional flexibility. Can they drive? Normally let them have parking, but perhaps they can have parking. Could they travel outside of normal perhaps commuting hours to be able to give a little bit more flexibility? The real risk, to be honest, is if the employer decides that they were going to dismiss them because they refused to go to work, and that could potentially be unfair. So it's really dialogue with what are they worried about? What can we do to work around this? And if there really is nothing to work around, will the employer now be in a position to decide, well, look, what we could do is put you on furlough? Right,
okay. And there's lots of variables in that as well, isn't there, as to where their place of work is and how they need to work as well. On that basis, though, Claire, sorry, just to jump over to yourself, let's say, for instance, you need your employees on site. There's no way you can get around this. Let's get to a real finite use case, which is, maybe you're an Amazon warehouse. There's no way that half your team can work remotely. Can you force the employee to attend work, even if they're still anxious with regards to contracting COVID?
Well, unfortunately, there's no one answer. It will depend on the circumstances, including the individual and their own circumstances, the type of work in question, and the working environment. Employers do have a duty of care to all their staff and must treat everyone reasonably and fairly, and must consult with individuals and be as flexible as possible when dealing with everybody's concerns, because everyone right now will have different concerns as to why they're willing or not willing to go into the office. And you need to have that conversation with people before going down any disciplinary route. Ultimately, it is the employer's choice as to whether or not they require their employees to attend. But you've got to follow government guidance, which is at the moment, you must work from home unless there is a reason that you can't. So in the circumstances where they are required to be in the office, you must ensure that you have followed all the government guidance in terms of social distancing. You could potentially take disciplinary action against employees where you are confident that you have done everything you possibly can practically to control the risk of transmission. There are obviously risks in any disciplinary action, given that this is a completely new circumstance. We've got no idea how the tribunals are going to interpret it or the outcome, and whether they would see that such dismissals were fair in the circumstances. So our advice at this time would be cautious, use the options available to you, for example, considering furlough, or consider unpaid leave, because employees are not able, ready or willing to work. They're not, in theory, entitled to pay. So those are the options available, but at the same time, you should try and encourage employees to come back to the workplace, explain what you've put in place so that they do feel safe. And also you've got to continue to support them with their mental health and well-being in the hope that they will return to work.
Okay, perfect. I think, yeah, there's a number of challenges, and the landscape's changing all the time as well, right? And so it's working through it. I guess just to make sure I've got this, the salient point there is use, as the employer, err on the side of caution, but use all the available opportunities to have an open and honest dialogue with your employee. Is that really what we're saying at the moment? To just, because of the tribunal, because there's no legal precedent set at the minute, is it always the best practice to be overly cautious and to really explore all the avenues of options available?
You need to make sure you follow the government guidelines, make sure that you have undertaken a risk assessment, done everything you can to make your workplace environment in line with those guidance, so that if you had to go down the disciplinary route, you can justify your actions on the basis that you've done X, Y, and Z to make the place as secure as it possibly could be.
And that's a great segue around the risk assessment side of things. Nikki, let's flip the scenario, right? I'm a super keen employee. I should be shielding, but I really, really want to come into the office and do my role. I'm a stellar employee, obviously. Right? In this situation, there are going to be other members of staff that are going to potentially be concerned. There's health and safety elements to think about. It's a bit more about just the individual, it's about the team. So what's the guidance there? What do we need to think about in that scenario?
Okay, so are we talking about, so you're a super keen employee, you want to be in the workplace. So obviously if we've got work for you to be doing and you want to be in the workplace, we've done all our risk assessments and your job requires you to be in the workplace, because don't forget, as Claire said, you have to be following the government guidance. If you're deviating from it, it's going to cause you problems in the long run. Then yeah, absolutely, you can be in the workplace, can't you? But if you're talking about somebody that, because you're talking about shielding, so actually if you are supposed to be shielding, if you are a clinically vulnerable person, then we as the employer do need to be a little bit careful on what we do. So obviously, yeah, everything, it keeps changing, doesn't it? So if we roll back to August of last year, for example, the government guidance was very much that clinically vulnerable people, actually, sorry, prior to that, clinically vulnerable people had to be shielding. Then I think it was in August of last year that clinically vulnerable people could be returning to the workplace as long as the workplace was COVID secure, which I'm sure is terminology that we're all very, very familiar with now. Now that position changed with the further lockdowns that we've now obviously all experienced / are experiencing, I suppose I should be saying. And at the beginning of January, we had further guidance from the government about shielding. So this is, as with the whole of the COVID situation, it is continually evolving and changing. So we need to make sure that we're obviously staying up to date with all the latest guidance. But the latest guidance now is that clinically extremely vulnerable people are strongly advised to work from home where they can. We also, it's really important to remind everybody that the employment law hasn't changed in the sense of, because we've got all the COVID guidance and like changes in legislation, that doesn't wipe out all the previous laws and legislations regarding discrimination, unfair dismissal and all of that. That's still very much there. COVID just amends parts of the law, will in time see changes to the case law, but it's still all very, very relevant. So we need to make sure that we still continue to treat people fairly in terms of people who've got any disabilities, etc. Now, so if somebody is clinically vulnerable, we still as the employer have an implied duty to take reasonable steps to ensure that we have a safe workplace and to ensure that we have a safe system of work. Now, if the government guidance is that somebody who's clinically vulnerable shouldn't be in the workplace, then I think a great deal of care needs to be taken. I think conversations, as Claire and Ollie have already said, conversations need to be had with the employee as to our concerns about maybe having them in the workplace. Is there any changes that could be made to their work pattern? Is there any temporary change? So if they have to attend work and they can't home work, is there any temporary job? And I say temporary job that we could offer to them in order for them to be able to home work, because they want to be working, but the guidance is that they shouldn't be in the office. If possible, they should be home working. So it's having open conversations with the employee to see whether there's any ways of making everything fit, but also securing their safety and well-being. Because I think if you don't, then it does expose you to some risk. Might also be questions and queries as to why does that individual want to be in the workplace so badly? Is there any is there anything going on in the personal life? You hear a lot about, obviously, unfortunately, domestic violence. Are there any issues there that perhaps we need to be alive to? Perhaps we wouldn't ordinarily have been alive to it because our employee wouldn't have been at home 100% of the time. There's lots of extra factors and considerations that we need to be aware of. Has the person got a disability? If somebody's clinically vulnerable, then potentially they may very well have a disability, and therefore we have the obligations under the Equality Act, of course, in order to consider whether there's any reasonable adjustments that can be made. So I'm trying to keep my answer as short as possible, but there's a whole load of considerations that need to be taken into account.
Yeah, for sure. And I mean, again, just thinking about this, you touch on some other points and looping back to the earlier conversations around self-isolation. Who doesn't love a holiday, right? I think pretty much everybody likes a holiday, wherever that is. I know there's not going to be many skiing holidays right now as a result of this, but for those people that do venture out and decide to go on holiday, the government's just announced a whole new series of criteria with regards to people coming into the UK from abroad, but likewise as well. Should your employees go, you know what, that 5 days holiday I carried over from last year, I'm going to use that on a fantastic snowboarding trip to I don't know, the Italian Alps. Upon return, is there anything I need to do or know about? And do I really need to take more holiday? Should I need to self-isolate? Becky, what's your thoughts around that process?
Okay, so well, as of today, I've just seen the government are advising people don't think you can go and book a holiday. So slightly different slant on what I was going to say. And also there's this possibility that we might be shoved in hotels as well, making it even harder. But for number one, I think it's unlikely to be considered a reasonable management instruction to tell your staff they can't go on holiday. It's interfering with their personal life and it's outside of their job. So you can't tell them they can't go on holiday. If the individual can work from home when they get back from holiday, and really the only risk is that they're going to have to self-isolate when they get home, well, again, that is not too much of an issue, unless, of course, they're holed up in a hotel, so they actually can't work from home anyway. But if what they can do is go on their holiday, they come back, they might need to self-isolate, but that's fine, because actually they can work from home and that's okay. The issue will be is if they can't work from home and you need them to go into work. And this is quite vague, and you can argue it both ways, actually, to be honest. There is one argument that they're ready, willing and able to work, and somebody else is stopping them from doing that. They didn't know when they went on holiday. I think it will come down to is what is the knowledge which they had when they went or when they booked. Did they know they would have to self-isolate when they came back for 2 weeks or not? And I think if they didn't know they had to self-isolate when they came back, although there is perhaps an argument that anybody at the moment should think they may well have to, because we know how quickly things can change. But if they went with the knowledge that when they came back, they would have to self-isolate and they couldn't therefore go into work, I think there's an argument that they shouldn't be paid. And that they're self-isolating, they're not entitled to their pay. They may be ready, willing and able to work, but they are prevented from doing so by the legislation. If they didn't know when they went that they would have to self-isolate, then there is an argument that actually they did it all within the best intentions, and actually it isn't their fault that they're having to self-isolate when they get back. And I think that's where we may see some case law around that, and that really will be whether, again, the same sort of thing, can they do self-isolation. It's become clear now that you're not entitled to SSP if you're self-isolating when you come back from holiday. What I would suggest is that employers sort of speak to their employees a little bit more than you perhaps normally would about what are your expectations. It could be up to employees to perhaps take unpaid leave when they get back. Nobody's really going to want to take 4 weeks. They're into whole holiday entitled to go on a 2-week holiday, but that could be, and employers are probably not going to want them outside the business for that long, but there could be opportunities to do that. I would say really trying to discuss with staff about, rather than laying down the law, discussing them with what are their expectations, what are you going to do, how are we going to handle this if while you're away you find out you've got to self-isolate, or you're making a conscious decision to go somewhere that is going to require you to have 4 weeks off work for a 2-week holiday. We need to discuss how we're going to manage those 2 weeks, because you either won't be paid or you're not entitled to SSP. And there is an argument whether they should be on furlough, to be honest. Why should the government pay for the 2 weeks for them to go on holiday? But that's a slightly different question. I think we will see quite a lot of arguments coming out of this, actually, in the future.
Okay, I mean, and again, it's a changing landscape all the time at the moment.
And this is quite a new thing that we haven't really had to deal with before, because I think now some people did manage to get away on holiday last year, but it was we realised quite how quickly things were changing. You were on holiday and then suddenly you had to self-isolate when you came back for 2 weeks. So there is now an argument, and particularly with the government coming out and saying, don't think you can just book a holiday, that anybody that goes on holiday now should really have the expectation that they may need to self-isolate. So did they have that knowledge before they went?
Okay. And likewise as well, where we're sort of going to go with this is we saw in 2020 the concept of air corridors with countries that were deemed to be COVID safe. And so we may see towards the summer months, the government starting to talk about these kind of concepts again, in that if you go to a particular country, then you won't be expected to self-isolate when you return. So it is going to be a very fluid landscape, I'm assuming. And it's just,
I think it will be, as we saw, it will change. It may well change while you're out there. And I think there's a stronger argument that those individuals should be paid, perhaps paid their pay or other flexibility rather than people consciously going out. But I think we will see the case law that we've got on this. There is case law about being paid when you're able to work, but you're being prevented by somebody else, what somebody else tells you can't do. But it's never been tested in this environment.
Fantastic. Yeah, wow. So watch this space, right? So Claire, sorry, sitting silently top left-hand corner in my gallery of people. if we have employees on furlough at the moment, what's the what are the regulations around redundancies and things like that? I know hospitality had this real big challenge towards the end of last year, leading up into Christmas, where they had staff on furlough. Was Christmas on? Was it not on? Etc. Etc. How what are the challenges around employee redundancies, especially if they're on furlough?
Yeah, so the purpose of the furlough scheme is designed to help employers avoid redundancies effectively. But unfortunately, I think this pandemic's gone on a lot longer than we probably all anticipated. And there's going to be such a global impact that unfortunately redundancies and staff cuts are inevitable. Now, there is an argument to say it would be unfair to dismiss somebody or make them redundant while the furlough scheme's available as an alternative. But you have to remember furlough is not cost neutral at all. Even if the employee agrees to reduce their salary to 80%, the employer still bears the cost of national insurance, pension contributions, holiday pay top-ups, and other benefits unless the employee has agreed to waive them in their furlough agreement. So there are still some additional payouts the employer has to make, which will have an impact on its business. There also remains a question mark over whether it is contrary to the purpose of the furlough scheme to use it purely to postpone redundancies. From what I understand from HMRC is the furlough should be used if there is a viable job at the end of it, not just to prolong the inevitable, effectively. So on that basis, we don't necessarily believe it would be unfair to make an employee redundant, but you just need to be able to justify why you cannot continue to keep them on furlough to the end of the furlough scheme. There is a risk, obviously, the tribunal could consider such a redundancy to be unfair, but we don't know that that's the stance they will take. And obviously every business is different. It's going to have different circumstances, and it may be facing insolvency and have no option but to make redundancies. One point I did want to make is if you did decide to do redundancies, being on furlough does not mean that the employment rights that employees have change in any way at all. So you would need to follow a fair redundancy procedure in order to avoid unfair dismissal. And one thing to point out in relation to the furlough scheme at this time is that notice pay is not covered under the scheme, and the employers would have to pay this separately. Previously, it's my understanding, I think maybe back in March, notice pay could have been covered by the furlough scheme, but not in this extension. So there are various points to consider. It's not a no, it's just you've got to make sure you've considered all possible opportunities, and redundancy is the final option, and you have no other option but to do that.
And it's interesting that you mentioned all other options. And the reason why I say that is from personal experience, a really good friend of mine down in London, his business that he works for, they did a 20% pay cut across the board. And they offered employees the opportunity, they have to, right? They couldn't just cut their pay. But the outcome of that is they said, look, we don't want to make any redundancies. If people are willing to take a 20% pay cut, we'll know we'll get through this as a team. And it's just a precautionary measure as a result of the impact to our bottom line. Pretty much everybody in the business just opted straight in for it. And they were open and honest about it. And actually in November time, they announced to all their employees, hey, thanks very much for taking the 20% pay cut. We're going to give it all back to you as a Christmas bonus because we survived through the period that we were most worried about. And so the employee wasn't expecting that the moment that they took the 20% pay cut. It was only in the November time they found out they were getting every penny back to them. But that's an example of real open and honest and transparent employers in the respect that they were they were comfortable having that conversation with their staff because they didn't want to go down the redundancy route. That said, and you touched on a great point, which is, it's not 100%, right? If you're on furlough, it's got to be topped up by the employer. And inevitably, as this is dragged on, there are going to be some employers that cannot afford to continue to top up that furlough payment. Nikki, is there any thoughts around how we can deal with that?
Yeah, that's quite an interesting one. So yeah, if you wind back nearly 12 months, I had a number of clients that were wanting to top up to the 100%. So they took the 80% and then they topped up the remaining 20%. Or depending on people's salaries, they topped up. It would be more than 20%, wouldn't it, if the 80% was more than the cap. Now, they were happy, probably. They were happy paying that for a while. And then some months later, it's a case of, right, this is going on longer than anticipated. We don't want to be paying them the 100% anymore. We do want to now be dropping it down to the statutory cap, to the 80%. My advice back then was to only pay the 80%, not pay the 100% for lots of reasons. One being that then if you wanted to be reducing it, it would be a bit more of a struggle, potentially, whereas back in March, April, employees were very happy to accept all sorts of things which they wouldn't normally agree to on the basis that they wanted to be keeping their jobs. There's also the other added complications regarding holidays, for example, is that actually there's not an incentive for somebody to want to be voluntarily taking holiday to get their 100% pay if they're being paid 100% pay for being on furlough anyway. But anyway, going back to your question, so if we've got an employer now that's paying somebody 100% and they're saying we just can't afford this, we need to be reducing it now down to the 80%. Well, as you said earlier, Ollie, no, you can't unilaterally change because the variation, you varied their contract, hopefully with express written consent, to not being at work but paying them 100%, but we don't need to be giving you any work, to be reducing that pay now down to 80% is a further variation. So you need to obtain express written consent from the employee to be doing that. Largely, some of it might depend also on what your furlough agreement with the employee says, but you will basically need to be getting them to be agreeing it with you. And if you just go ahead and enforce it on them, then you are opening yourself up to potential claims, so potential constructive unfair dismissal claims, potentially breach of contract claims, unlawful deduction of wages claims, and possibly discrimination arguments. If there's a particular group of people, let's say disabled people that are furloughed, let's say, and all those furloughed people are now being subjected to a detriment, there could possibly be some form of arguments to be formed there. I think they're a bit lesser, but again, on a on a case-by-case basis. So you'd have to obtain their agreement, basically.
Okay. Yeah, I mean, again, it makes sense. It's all about having that conversation and being as open and as kind of pragmatic and transparent as possible.
Yeah, you're right, Ollie. I think you say, I think it's because a lot of my clients have had to be, I say to them, have frank conversations with your staff. Tell them where you're at. Tell them how your business is suffering. Obviously it's a bit difficult if you're booming, but have these conversations that you might not normally perhaps be that open and frank with your employees. Have the conversations with them, get the buy-in off them. Most people still want a job at the end of this, even on a reduced pay.
Absolutely.
The alternative is redundancy, then they may be willing to accept it for this period of time. At the moment, if there's so many redundancies being made and not many opportunities, then hopefully they would see the bigger picture as well.
Yeah, and actually, again, it bleeds into another great question, which is, if I think about this last couple of weeks, playing business owner, maths teacher, PE teacher, dinner lady in all the same day has been somewhat challenging at times. But I'm fortunate enough where I'm able to do that and still work. In a scenario where somebody has a dependent, but they can't come in, they need to come in, it's the only way they can do their job. do they have a right to ask to be furloughed because they need to look after the children because they can't attend school at the moment? Becky, what's the scenario there? Because dependents leave and dependents care is quite a sensitive subject as well, right?
Yeah, well, you and me both, Ollie. Luckily, mine are old enough to be able to do their schooling by themselves. But if I had a 2-year-old and 4-year-old running around, I think it would be really quite different. On the bit about dependence leave, that's emergency leave. So I will leave that to one side. But you do have a right to unpaid emergency leave to care for somebody, and that is separate to this. But if there was an emergency, that would cover that. It's really around whether or not you can request furlough for childcare, and the government have now made it clear that an employee does have a right to request does have a right to request to be put on furlough for childcare for reasons connected with COVID. Okay, so if the schools are closed, if the child isn't well, or something like that, not just because. And it arose perhaps slightly, and I had a couple of clients with this when the schools reopened. I want to work part-time because I want to go on furlough. Well, it's not for a reason connected to COVID. You don't have to do it. So you do have a right to do it, request it for reasons particularly with COVID. So at the moment, while schools are closed, yes, certainly people can request to go on furlough for childcare reasons. However, the employer doesn't have to accept it. They don't have to accept it. What I would say is you've got to be mindful of you've got to be mindful of discrimination as well. It's pretty much accepted that women predominantly have the childcare responsibilities. So there is an argument, if you take a hard line about not giving somebody time off, you could be indirectly discriminating against women on the grounds of sex by doing that. So that's something to put in. They also have the right to general flexible working requests. So yes, they can ask for it, but they don't have to have it. What I would consider is if you're adamant you want people to work, think what flexibilities you can put in place. Could they work different hours? Could they work more flexibly, reduce their hours, do something? I think generally people are trying really hard to make this work. So if there's a particular reason why you don't want them to go on furlough and you actually still want them to work, then in order to avoid any sort of arguments that you might be discriminating or possibly even breach of contract, if it's so unreasonable, then what movements could you as a business make to be able to accommodate that if you still want them to work?
Okay, fantastic. I know on the flexible working side, I've used that myself about a decade ago, and managed to end up working from home a few days a week when I was looking after my son. The outcome of this, though, is that the government's put various controls in place to try and help because they appreciate the scenario. And I think, again, that's another honest conversation. I know that when I applied for flexible working, I sat down with the team and just said, look, you've got two options, right? I can't do this and bring up my son, so you're going to have to make me choose between one of the two, or we can sit down and we can come up with a compromise. Unfortunately, we went down the compromise route. Claire, just really quickly, just to sort of cover this out.
Working, just quickly, the thing, if you do a formal flexible working request, obviously you can only do one in a year. So if you can agree something for what are really quite unusual circumstances on an informal basis, it does keep that, it does sort of keep that up the employee's sleeve. So
we did it the other way. We agreed everything on an informal basis, and then they said, hey, could you put in a flexible working request so that we look good on the stats? So just to kind of close out, because I appreciate we're top of the hour, Claire, I mean, what are we all doing about this vaccine? Some people want it, some people don't want it. There's lots of press about the fact that there's delays. AstraZeneca have got challenges going on with it. So is the Pfizer vaccine. What's the legal precedent here around an employee having to have the vaccine? Is there anything in place today, or is it again just a moving target?
It's definitely a hot topic at the moment, and I think the conversations are just starting. But firstly, let's have a look at what the government's actually said about the vaccine. Oh, is that somebody? Anyway, so there is no legal basis on which the government can rely on which to force people to have the vaccine. So nobody's going to be forced to have it if they don't want to have it. And if they did, it's likely to bring up objections on the basis of human rights. So instead, what it wants to do is educate and persuade people that the vaccine is safe and that it is in everyone's best interest, so we can get back to some sort of normality. So would it, in an employment environment, be a reasonable instruction to ask a member of staff to take the vaccine? Well, again, it depends on a number of factors. The most important of which is whether the vaccine will protect members of staff or other people that they come into contact with, such as patients, school children, customers, service users. So it's not just about individual risk, it's about those around us. So at one end of the scale, for example, like healthcare professionals, they are much more likely to come into contact with patients and pass the virus potentially on to others. Therefore, it's likely to be a reasonable instruction for frontline staff to be vaccinated. But it'll be much less reasonable where staff have limited contact with other people, and that there are other measures that you can put in place to ensure that there is no transmission or reduced transmission. So if you decided to make it a reasonable request for staff to be vaccinated, what do you do if they refuse? Now, as we've said, I think with a lot of answers, it will depend on a case-by-case basis, and some people will have a specific reason why they will not have the vaccine. For example, somebody may be advised from a health perspective not to have it because it may impact on other treatments they're receiving. And staff may also be worried about the vaccine. So you need to be in a position to be able to discuss their worries and try and maybe direct them to information about the vaccine rather than all the scaremongering that seems to be going around on social media. And you also need to consider whether individuals who are refusing it are protected under the Equality Act, because there are some religious groups who disapprove vaccinations. So potentially, if you put a policy in place that says that they have to have a vaccine, you could be discriminating against them. So in terms of it, I think it's a case-by-case basis, depends on the working environment that you're in, how much contact you're coming into with individuals. At the end of the day, it doesn't mean you can't do it, but it has to be the last option available, and employees need to know that potentially they could be dismissed. Yeah, and they need to be aware of the potential outcomes.
Yeah, there's a lot to think about. The other thing as well is, this is not a question, but if somebody does become sick after taking the vaccination, do they go on to statutory sick pay there if they're going to have to be at home for a week, 2 weeks while they recover? So again, it's a bit of a minefield, but I can see that most employers are going to want basically to keep their staff safe, right? That's really the outcome here. But yeah, there's an awful lot to think about. Some fantastic answers. Really appreciate the time and effort you guys have put in today, and also the planning behind the scenes. I think this is a fantastic session just to really help people get some confidence that there are some hard facts going on in the background that people can start to think about. But the most important takeaway, and I think you summed it up, Nikki, which is, as an employer, just be open and honest. As an employee, have those dialogues. Everything should be on the table right now in terms of being able to get through this. And I don't think there's any employers out there that want to lose, staff, right? There's always going to be that one person that most employers go, really? But the outcome of this is that, it's something that we have to get through as a team, above all else. With that, the Bridge, I'm just going to loop you in just to round out the session. But yeah, once again, from me, thank you very much. And thank you to everybody that attended. But John, over to you to wrap things up.
No, I obviously just want to say thank you, but also just to say that I have had the vaccine, so I'm still alive and everything's still working. So it was the AstraZeneca one, in fact. So hopefully that's the best one to have at the present time, with the problems with Pfizer going on. But nevertheless, I really want to thank Claire, Nikki and Becky, because it's been an interesting session and just shows the problems that small businesses have coping with all the challenges, let alone the operational challenges, but the legal situation in relation to the people that they employ and the different aspects they've got to look at in relation to all of the different employment aspects and the holidays and the different categories they're in, and clearly the involvement and the sick pay situation and how it all works together. But I think it's been really, really helpful this afternoon, and thank you all very much, because it helps to bring it into focus and help us to understand, exactly how we need to think about it. But more importantly, I think it brings home to us that when we get challenges like this, we need to speak to specialists like yourselves to get some clarity to make sure that we do follow the way that we need to ensure that we are responsible employers and do what is appropriate with every individual. So thanks a lot, and I know everybody would have found it of great benefit, and I'm sure we'll be looking at hopefully having some more sessions like this, because I believe the challenges that employers are going to face are not going to diminish at all, but get more challenging, and it's really, really helpful to be able to highlight these things and help people to understand the pitfalls that could be there if they don't understand what they need to do. So thanks a lot, and that's really all from me. Ollie, back to you.
Yeah, no problems. Thank you, John. And then just to round out, Nikki is the chair of the HR Leadership Forum at the Chamber. There's a lot of plans going on in the background. Is there anything we can discuss today to people to watch out for in the future, or do you want to leave it as a surprise to find out on LinkedIn?
Yeah, I should actually just say, because I don't know, I can't remember, it's an hour ago. So I don't know whether Ollie introduced, obviously I'm an employment lawyer, Claire is an employment lawyer, and Becky is an employment lawyer as well, all at different firms, however. And we, and Ollie as well, we're all on the HR sector forum. And yes, I think it's next week, because I think we're in February, aren't we?
4th of Feb? Is it
next week?
It is the 4th of Feb. Sorry, it was a rhetorical question.
But we have our next HR. So for those of you that aren't aware, the HR sector, every month, the first Thursday of every month, we run a session covering a variety of different issues. I think the next session is looking at the workforce and workforce planning going forward. The next session won't be so much considering the legal issues. So obviously HR covers operational, strategic, legal. The next session will be thinking from a practical point of view, more so in respect of workforce planning going forward. And it's been very difficult this year, hasn't it? Because I know a lot of my clients have been at very different stages at very different times. So yes, feel free to sign up for the next session. It will be conducted by, I think there's going to be 4 or 5 speakers, again from the committee. We have a large number of people on the committee covering all sorts of different background experiences, which is great because it brings in lots of different dynamics. And then I think the session after that is going to be looking from a legal perspective, again in respect to changes to workforces, whatever that's going to be entailing, who knows. So yes, awesome. please do have a look on the website, check your emails from the Chamber, and look forward to seeing you all there. And thank you, Ollie, by the way, for facilitating these sessions. Hugely appreciate it.
No problems, you're welcome. And yeah, so thanks to everybody that attends. We'll circulate around the recording. There will be some links to some other useful information, and also I'll make sure that you 3 have a LinkedIn link in that email as well. So if anybody wants to reach out, they can do so. And yeah, look forward to speaking to most people on the 4th. So thank you very much. Take care. Have a good day. Thank you.
Bye-bye.
Thanks, Ollie. Thanks. Thank you all.
Thanks. Bye.